Welcome to our webinar, Options for Survivors of Crimes, Including Trafficking. My name is Serena Bhatia, and I am a senior staff attorney at the Children's Immigration Law Academy, or CILA. This 101 webinar is being recorded on September 29th, 2022. It is one of a series of webinars we have available for advocates who are new to the field of children's immigration law. Please note that immigration law changes rapidly. It is important to stay up to date with case law, policy updates, and any procedural changes. CILA is a project of the American Bar Association's Commission on Immigration. CILA is a legal resource center, and we aim to build the capacity of legal service organizations and pro bono attorneys to represent children facing deportation. There is no right to appointed counsel in immigration court, even for children, and we believe every child should have an attorney at their side in immigration proceedings. Before we move on with today's topic, here's a reminder of the services we provide here at CILA. We are based in Houston, Texas, and we now provide national services. We provide technical assistance regarding case-specific questions relating to children and youth in their immigration cases. We offer 4 national working groups relating to asylum, SIJ status, pro bono, and working with detained unaccompanied children, and 2 Texas-based working groups, which are Houston SIJ status and social work. The purpose of these working groups is to provide spaces for advocates to collaborate. We also provide training, such as this one, and written resources, which are all available on our website. And finally, we host a platform featuring pro bono opportunities across the country and provide resources related to pro bono work. As mentioned, we offer free resources on our website, cilacademy.org, including a pro bono guide that details how to work with children and youth in their immigration cases. Okay, we're going to jump in. So in today's webinar, we are covering options for survivors of crime. The 2 forms of relief we are going to discuss are U visas and T visas. VAWA, or Violence Against Women's Act, is also available for victims of crime, specifically victims of domestic violence, but that has been discussed in a different webinar under family-based immigration options. First, we're going to get started on the U visa. So the U visa is reserved for victims of violent crime. The sources of law are the Trafficking Victims Protection Act of 2000, the TVPA, and the Violence Against Women Act, or VAWA, of 2005. These have been codified in the INA at 101A15U and INA 214, 212, and 245. The relevant regulations are at 8 CFR 212.17, 214.14, and 245.24. The U visa was created because authorities found that there were significant crimes happening in immigrant communities that were not being reported because immigrants who were the victims of those crimes were afraid to report them to police out of fear of being deported. So the U visa was created to help immigrant victims of crime come forward and report their crimes without recrimination. Moving on to the requirements for a U visa. So there are 4 requirements. First, the person must be a victim of a designated crime that occurred in the U.S. or violated U.S. law. Second, the person must have cooperated with law enforcement. So that means that they must have information about the crime and have been or is being or is likely to be helpful to the investigation or prosecution of the crime. Third, the person must have experienced substantial physical or mental abuse as a result of the crime. And fourth, and finally, the person must be admissible to the United States or be eligible for a waiver. Before I go into more detail about the elements of a U visa, I do want to talk briefly about the benefits of a U visa for the immigrant. First of all, it gives the individual lawful non-immigrant status for 4 years. It also provides employment authorization. And then eventually the person will be eligible to apply for a legal permanent residency or their green card after 3 of the 4 years of lawful U status. And their derivative beneficiaries are also eligible for the same benefits. Going back to that first requirement for U visa eligibility, which is that the person must be a victim of a designated crime. So what are these designated crimes? What qualifies? And on this slide are some examples of qualifying crimes. The crimes could be trafficking, sexual exploitation, involuntary servitude, rape, sexual assault, abusive sexual contact or incest, domestic violence or felonious assault, kidnapping, false imprisonment, abduction, manslaughter or murder, witness tampering, attempt, conspiracy, or solicitation to commit any of these crimes. And stalking is a newer addition to the statute, which was added by the Violence Against Women Reauthorization Act of 2013. There's a full list of 28 crimes in the INA at section 101A15 U3 So you can go there to check out whether the crime your client has been a victim of would be qualifying for a U visa. There's actually another part to the first element of the U visa requirements. So the person has to be the victim of a crime. So who exactly qualifies as a victim? There are basically two types. One is a direct victim, which is what you would think of, the person who, or a person who has suffered direct harm or who is directly or proximately harmed as a result of the criminal activity, which is defined in the regulations. And it can also actually include bystanders or people who were not the intended victim of the crime if they suffer unusual injury as a direct result of the crime. Some examples would be if somebody is hit by shrapnel from a bomb or a stray bullet, or if someone unfortunately has a miscarriage due to the trauma of witnessing a crime. Those people as bystanders could qualify as direct victims. The second category is indirect victims. This means that for some reason the person applying is not the person the crime happened to. This would happen, for example, if the victim of the crime is a US citizen minor under the age of 21. In that case, their parents can often be eligible as indirect victims for the purpose of a U visa. If the victim was a victim of murder or manslaughter, or is incompetent or incapacitated as a result of the crime, or because of age, then certain family members may qualify as indirect victims. These would include siblings under the age of 18 and parents. You could also look at adult victims where an adult has been the victim of a crime. Their spouse and unmarried children under the age of 21 may also qualify as indirect victims. And finally, a note that persons who are themselves culpable in the qualifying crime are not considered victims. The second element in the U visa requirements is that the victim has cooperated with a law enforcement agency. So you establish this by submitting a Form I-918 Supplement B. This is known as the Law Enforcement Certification, and all applicants must submit this. If the victim is under the age of 16, the parent can be certified as having cooperated with the police instead of the child. And it's important to note that there's actually no requirement that the perpetrator of the crime be caught or even prosecuted. So for many certifiers, an initial report of a crime may be sufficient if the victim was not subsequently contacted for assistance. Additionally, the U visa applicant cannot reasonably refuse a request for assistance even after the certification is signed. So if there is a reasonable request for assistance made by the investigator or prosecutor, the applicant cannot refuse that request. And finally, best practice is to keep an updated list of certifying agencies, policies, and designated certifiers. Some certification requests are time sensitive because of agency policy. So you know you have to file the I-918B and have it certified that the victim cooperated with law enforcement, but how do you go about getting that certification from the law enforcement agency? So first, you need to determine what agency or agencies could potentially certify. One example is the police department that initially received the report of the crime. And you could also potentially get a sort of certification from the district attorney who is prosecuting the perpetrator of the crime. If the agency is a large one, they may already have a U visa certification policy. If they don't, you may have to educate the agency on the protocol and the purpose of a U visa. To find a certifier for a law enforcement agency, try asking for the victim coordinator. This means that not every individual at an agency is qualified or authorized to make the certification for U visas. So you do have to find the individual person with that authority at each law enforcement agency. The Immigration Center for Women and Children, ICWC, maintains a national list of U visa certifiers. If you subscribe to that, it can help you determine the appropriate person to contact to get the I-918B certified. For getting an I-918B certified is to pre-fill the form for each agency you're sending it to. We also recommend you send it with a copy of the police report or any court records and a cover letter to the certifying agency explaining what you're asking for. Once you get the certification back from the law enforcement agency, we also recommend carefully reviewing the response. Sometimes an agency may sign the I-918B, but will indicate that the victim was uncooperative, which could be a big problem for their U visa eligibility. We also recommend that you avoid sending a client statement along with the I-918B to avoid any potential conflicts between a client's memory and the officer's report. Because remember, anything that you send to a law enforcement agency is potentially discoverable during any criminal proceedings. And one last thing, which is really important, is that if you are successful in getting a certification, it is only valid for 6 months from the date of the signature. So within that 6-month period, you have to submit the U visa petition along with that certification to USCIS. If you don't do that in time and the certification expires, it can also be difficult to get it recertified. Some law enforcement agencies even have a policy against recertifying. The third element of U visa requirements is that the victim has suffered substantial mental or physical abuse as a result of the crime. So what does this really mean? Essentially, USCIS will make a case-by-case determination about this. So in determining whether the victim has suffered substantial abuse, they're going to consider the following factors, which again are laid out in the regulations: the nature and severity of the injury, the severity of the harm suffered, which includes potential aggravation of existing conditions, the severity of the perpetrator's conduct, the duration of the infliction of harm, the extent to which there is permanent or serious harm to appearance, health, physical or mental soundness, which can mean a lot of different things as it's quite broad. And this also includes a pattern of abuse, especially in situations of domestic violence. It's important to note that this is a subjective standard, so it is determined from the point of view of the applicant. So the applicant's particular background, age, education, mental health, and similar other factors will be taken into account as well. So that's good to know that when you are working with children, this determination will be made from that child's perspective, taking into account their situation. U visa applicants are allowed to include derivative family members on their applications. This is different from what I was mentioning before, where you can have indirect victims of crime, where potentially parents may be able to apply when their children was a victim of a crime, or a child can apply when their parent was a victim of a crime. These are people where the principal applicant is the direct victim of the crime, but they can include certain family members in their application as derivatives. There are two main rules. The derivative individual must be a qualifying family member of the principal at the time of filing, and the person must be admissible or qualify for a waiver and not be culpable in the qualifying crime. So an example is if an individual is the victim of domestic violence, the spouse that perpetrated that abuse could not then be a derivative family member on the U visa application. If the principal is over the age of 21 at the time the application is filed, the derivative family members can be a spouse or unmarried children under the age of 21. If the principal is under the age of 21, they can include their spouse, unmarried children under the age of 21, unmarried siblings under the age of 18, and their parents. The controlling fact here is the principal and the derivative's age at the time of filing the U visa application. So watch for potential deadlines to avoid aging out. Once you file, however, the age of the derivatives for the purposes of filing in these derivative family members, those ages will freeze. The applicant for a U visa may apply for derivatives who live in the US or abroad. If the derivative lives abroad, they would need to wait for the principal applicant's full U visa approval to go through consular processing in order to enter the US. The applicant may apply for derivatives who live in the US or abroad. If the derivative lives abroad, they will need to wait for the principal applicant's full U visa approval to go through consular processing in order to enter the US. On the topic of U visa processing times, in the past, U visas were not flowing very smoothly through the entire process. The Victims of Trafficking and Protection Act of 2000 limited U visas to 10,000 visas available per year. This created a huge backlog in the number of people who are able to obtain a U visa. This is because if no U visas are available upon the decision, the applicant will first get conditional approval, which does grant them deferred action, and then they would get put on a wait list with that kind of conditional approval. They would obtain deferred action and a Category C14 work permit for 2 years. However, they would be waiting for quite a long time for that full approval, and then eventually for the full approval of the U visa petition. In response to this, in June 2021, USCIS updated its policy manual to implement a new process referred to as the bona fide determination. This enables USCIS to review petitions more efficiently and provide the benefits of employment authorization and deferred action to more petitioners in a shorter period of time. The purpose of this policy change was to provide additional safeguards to U visa applicants. So for petitioners for U non-immigrant status or for U visa with pending bona fide petitions, which means that they were made in good faith and without the intention of deceit or fraud, if they meet certain discretionary standards, they can be granted this bona fide determination. Essentially, the requirements for the bona fide determination are that the principal petitioner must have properly filed a complete petition for U visa status, including all required initial evidence, and the form must be complete. And the second requirement is that USCIS has received the results of the principal petitioner's background and security checks based upon biometrics. And if these two requirements are met, and again, this is a discretionary grant, USCIS may grant the bona fide determination, which would provide the benefit of that deferred action and a work authorization for 4 years. If the bona fide determination is not granted, that does not mean that the U visa application is denied. It just means that USCIS will consider the case as it usually would or previously would for that waitlist placement and conditional approval. So now with this new process, generally the process of applying for a U visa looks like this on the slide. So you as the attorney would start with a screening and intake appointment. The attorney then requests that I-918B from the law enforcement agency or district attorney. Once the I-918B which is the certification. Signed, the attorney and client will prepare to file the case. The attorney then files the case with USCIS using that form I-918 along with the certification on I-918B. And from there, USCIS will review the application and on a discretionary basis, determine whether to grant a bona fide determination. If that's not granted, again, USCIS will consider the application for conditional approval, which, if approved, comes with a temporary EAD as well. After that, ideally, and hopefully full approval would be granted. And then finally, the client would be eligible for adjustment of status after 3 years of this full visa, U visa status. Okay, that wraps up everything for U visas. Now we're going to move on to discuss another option for immigrant survivors of crime, which is a T visa. So the T visa, as the team might suggest, is for immigrants who are victims of trafficking. First, a note, because many practitioners who work with unaccompanied children when they're in the ORR shelter will see that the child may have been given an OTIP letter. This letter comes from the Office of Trafficking in Persons, which is part of the Administration of Children and Families under the Department of Health and Human Services. An OTIP letter is not the same as a T visa. So an OTIP letter is an indication that someone believes that the child may have been trafficked at some point. So two notes on this is first, this letter does not mean that the child has a T visa. And second, it doesn't even mean that the child is eligible for a T visa. So additional screening in further detail is always necessary in those situations. I will explain a little further in a bit on why the OTIP letter does not necessarily mean that the child is eligible for a T visa. Okay, so going into the sources of law for the T visa, which again is for victims of trafficking. The sources of law are the Trafficking Victims Protection Act of 2000, which is the TVPA, and the Trafficking Victims Protection Reauthorization Act, the TVPRA, of 2003, 2005, 2008, and 2013. These statutes are codified in the INA at 8 U.S.C. The specific provisions are INA 101 A15T, 22 U.S.C. 7102, back to the INA 214 subsection O, 212 D13, and 245L related to adjustment. The regulations are at 8 CFR 214.11, 28 CFR 1100.35B, and then back to 8 CFR 245.23, again for adjustment. So the elements required for a T visa, as laid out in the INA, are on the slide here. First, the applicant must be a victim of a severe form of trafficking in persons. The applicant must be present in the United States on account of trafficking. Third, the applicant has complied with any reasonable request for assistance in the investigation of trafficking or is less than 18 years of age. Fourth, the applicant would suffer extreme hardship involving unusual and severe harm upon removal. Fifth, and finally, the applicant must be admissible or must be eligible for a waiver of inadmissibility. You may note that this last requirement is the same for U visas and T visas, and we will go over that together for both of them at the end of these elements of the T visa. Okay, so we're going to break down these elements further, one at a time. The first requirement being that the person is a victim of a severe form of trafficking in persons. Okay, so what is a severe form of trafficking? The TVPA of 2000, again codified at 22 U.S.C. 7102 subsection 8, provides the following definition of severe forms of human trafficking in persons. Sex trafficking in which a commercial sex act is induced by force, fraud, or coercion, or in which the person is under 18 years old, or the recruitment, harboring, transportation, provision, or obtaining of a person for labor or services for the purpose of subjection to involuntary servitude, peonage, debt bondage, or slavery. So when working with unaccompanied children, it's good to know that what the most common offenses that we see when working with minors. So they are sex trafficking, the definition of which can be found at 18 USC 1591, forced labor, which is found at 18 USC 1589, and domestic servitude, which is at 18 USC 1592. First, we're going to break down the definition of labor trafficking related to and through the lens of a child. So essentially, labor trafficking can be broken down into three parts. There's the process, the means, and the end. And there must always be one of each of these. A process would be recruiting or harboring or moving or obtaining a person. Means would be the way that it was done. So was it done through force or fraud or coercion? And the end is why. For what were the purposes? So was it for the purposes of involuntary servitude or debt bondage or slavery? Again, there must be one process, one means, and one end. For example, you could say that the trafficker moved the child through fraud for the purpose of slavery. So this is how to frame and describe the severe form of labor trafficking. And just a note, the statutory language contemplates even ultimately unsuccessful trafficking schemes. So as long as you can establish the process, the means, and the end, it doesn't necessarily have to be a successful scheme. And then when we look at trafficking offenses related to child sex trafficking, those three parts are rather condensed into two. So the process and the means become the same, and they are just inducing a minor. So the difference here is that force, fraud, or coercion is not required. And then the end for the purposes of a commercial sex act. So essentially, if a person induced a minor to have a commercial or participate in a commercial sex act, that would qualify as child sex trafficking. Going to the second requirement for a T visa, that the person be physically present in the United States on account of the trafficking. We're going to talk about this in more detail because previously this definition of on account of had been narrowly interpreted to mean that the trafficking itself must take place in the United States. However, in recent years, USCIS has broadened their view of the physical presence requirement. So generally, if you can tie the severe form of trafficking to why the T visa applicant cannot leave the United States, you can show why the applicant has remained in the United States and is therefore physically present on account of said trafficking. So you might have the question, what if the child escaped from the trafficker? So it's also not required to show that the child did not have the chance to leave. Again, as long as you can show that the child has not left the US because the trafficking occurred. So let's say they are now in ORR custody, or they need access to and are receiving resources or help in the United States, or they do not have the physical ability to leave. You can say that they are in the United States on account of the severe form of trafficking. So as with the U visa, the third element in the T visa is that the applicant must have complied with any reasonable request for assistance in the investigation of the trafficking. The certification is submitted through Form I-914B. It's good to know, however, that the statute also says that this is generally not required for minors. So that means that generally when you start working with an unaccompanied child who was a victim of trafficking, it's more than likely that they will not have reported the trafficking to law enforcement. So As the attorney, you should facilitate making that report and accompany the victim to the interview, especially if they are a minor, and you and your client decide to report. Some agencies that you can consider submitting the report to, again, depending on the facts of the specific situation, are the Human Trafficking Task Force in your area, if there is one, a regional FBI, Homeland Security Investigations, or Department of Labor office, depending on the type of trafficking you're dealing with, or a local law enforcement agency, though those will generally have less training on human trafficking. They can still investigate and certify. Also, agencies often give special consideration to minor victims of trafficking. And just a practical consideration to keep in mind when working with unaccompanied children is that reporting can be helpful if the applicant wants to bring over, derivative family members to include them on their application. However, you want to weigh this against the possibility of re-victimizing the child or bringing up or somehow creating a difficult situation for the child by encouraging them or having them report. So it is not required under the INA for a child under the age of 18 to report to a law enforcement agency. So you'll really want to balance that consideration of whether it would be beneficial or detrimental to your client to report in their case. And then going on to the fourth requirement for T visas, which is that the applicant will suffer extreme hardship involving unusual and severe harm upon removal. The concept of extreme hardship is found in many places generally in immigration law. However, it's not perfectly defined. So instead, USCIS uses a series of factors in considering extreme hardship for a T visa, which are laid out in the regulations. And these factors include the T visa applicant's age and personal circumstances, physical or mental illness, trafficking related physical or psychological consequences, loss of access to United States courts and the criminal justice system, the laws, social practices, or customs of the home country, the risk to the physical safety of the child or the risk of re-victimization, and finally, the risk to the individual to their physical safety due to civil unrest or armed conflict. Again, similar to the U visa, T visa applicants can also include derivatives on their applications, and the same categories apply here as with the U visa. So just to go over those again, if the principal is over the age of 21, at the time the application is filed, the derivative family members can be a spouse or unmarried children under the age of 21. If the principal is under the age of 21, they can include their spouse, their unmarried children under 21, unmarried siblings under the age of 18, and their parents. There was also a change in the regulations in the last few years that extended the categories of family members who can be derivatives. So the standard here is if they face a present danger of retaliation because of the principal's escape from trafficking or cooperation with law enforcement, they may be eligible to be included as derivatives on the T visa application as well. This is also where it can be important to include that law enforcement certification on Form I-914B that we just discussed, especially in a common situation or example is when you're working with children, if they have siblings over the age of 21 or siblings that are married, having that certification and then being able to extend these categories of derivatives to those family members can be helpful. Generally, T visa derivatives are eligible to apply for work authorization if or when they are in the United States. If they are outside of the United States, they must consular process before entering with the approved T visa. They can actually contact the International Office of Migration, which can often handle the consular processing and pay for the travel costs for the derivative to come to the United States. So unlike U visas, there are 5,000 T visas available per year. However, it is very rare for these applications, for the applications filed in any given year to exceed 5,000. There's rarely more than a couple thousand received. So this actually means that once the T visa is approved, there's generally going to be a visa available immediately. That said, T visa applications can still take several years to be adjudicated. As of August 2022, the estimated processing time for an I-914 filed with the Vermont Service Center was indicated to be 21 months. And as of September 2022, that processing time for 80% of those cases are completed within 19 months. So if the T visa is approved, that will grant T1 non-immigrant status and employment authorization for 4 years. 3 years after obtaining that T visa, the applicant and any derivatives can apply for adjustment of status to a lawful permanent resident. Additionally, approved T non-immigrants are usually eligible for public benefits. Speaking of those public benefits and social services available for child survivors of human trafficking, this is also where that OTIP letter can come in handy, because that will qualify the holder of the letter to be eligible for some benefits as well. These are social services at the federal level. So for example, an individual can, with either an OTIP letter or T visa approval, can access food stamps or SNAP, public housing, medical services, monetary assistance, federal student financial aid, and another benefit which is important for the children we work with is the Unaccompanied Refugee Minors Program, or URM. So this is especially important if the child has no one that they can reunify with from the ORR shelter. If they are given an OTIP eligibility letter, they could be eligible for the URM program. And finally, going back to that last requirement of both U and T visas, which is that the applicant must be admissible or eligible for a waiver. Under INA 212 D14, almost all grounds of inadmissibility, including entering without inspection, may be waived for U and T visa applicants and must be waived before either application can be approved. This means that you would submit a waiver of inadmissibility to request this using Form I-192. Note that when working with unaccompanied children, you will find that many of your clients will require a waiver at the very least for entering without inspection, which triggers the inadmissibility ground at INA 212 A6A, and possibly for failing to possess a passport, which also triggers INA 212 A7B I. There are some grounds of inadmissibility that cannot be waived. These include Nazi persecution, genocide, torture, and extrajudicial killings. Another note is that after the 2013 VAWA reauthorization, inadmissibility under public charge, which is INA 212A4, no longer applies to U or T applicants, so they do not need a waiver for this ground. Usually, waivers are discretionary, so the standard is laid out in matter of Hranka, that's HRANKA. Generally, if the waiver is in the public or national interest, it will be granted. And a final note, waivers while in removal proceedings. The statute states that authority in U visa cases rests with DHS. However, there's a recent, in the last few years, a Seventh Circuit case which gave concurrent jurisdiction to the immigration judge, and that is cited here on the slide, which is LDG v. Holder. Before we wrap up, I wanted to mention some special considerations when we're considering doing U and T visas with child survivors of crime or trafficking. You want to be aware that the child's declaration may take several meetings. Remember that trauma affects memory and recall, especially with children, so it can be very difficult to remember specific details of what exactly happened. It's also good to use the same words the child does to talk about the crime and what happened to them. that can help in building rapport and also approaching it the same way that the minor is in their own experiences. It's helpful and important to be non-judgmental in your questions. You just want to be very aware of how you're asking the questions. You also want to be aware of potential re-victimization. As they tell you about what happened to them, they're going to be reliving it, and that can be really difficult. So you can always encourage your client to attend counseling in order to help manage the stress and effects of this. Another note regarding the perpetrator of the crime. So it is possible for those perpetrators to be in the child's family, and you may find out that it was in fact a close relative. If that is the case and the child and the relative are consolidated in their removal proceedings, you would definitely want to do a motion to sever those proceedings and just keep that in mind in the rest of the case as well. You'll want to warn and just remind your client of the effect of any future arrests on their application, because these things do have to be disclosed and can affect their eligibility for U or T visas. And lastly, and most importantly, make sure you're always protecting the safety and confidentiality of the child. Make sure they are safe and that they know that you'll be keeping the information that they're sharing with you safe as well. And finally, a few last tips for immigrant survivors of crime who are also currently in removal proceedings. A note that if the child is detained or in ORR custody, interviewing them and getting the full story can be really difficult just due to the limitations of access and privacy in those shelters or detention centers. So if necessary, you can file a skeletal or bare bones application and supplement it later when they're no longer in custody or you're able to better access the information in a safe environment. In immigration court hearings, you can also request closed and confidential hearings when discussing any details of victimization. We recommend requesting prosecutorial discretion from DHS. Currently, as of September 2022, the Mayorkas memo on DHS enforcement priorities is enjoined, but you can still submit case-specific requests to DHS for prosecutorial discretion, in which you highlight the individual's equities and case-specific considerations. We recommend you can request dismissal or administrative closure or other forms of PD. And you can visit the ICE Office of the Principal Legal Advisory website on prosecutorial discretion, which remains updated with the agency's current policies. And finally, if PD is not granted, which you can also request a continuance as a form of PD. However, if you end up needing to make a motion for a continuance on your own, just a note that matter of LABR is technically still good law, which may make it difficult to get continuances depending on the particular immigration judge. However, the case in re Sanchez Sosa has not been overturned by LABR or subsequent cases, and that actually lays out the factors the immigration judge will look at when considering a continuance so that you can look at that when making your motion. As we wrap up, I would like to tell you about CELA's pro bono platform called Pro Bono Matters for Children Facing Deportation, which we host on our website. There are many children and youth who do not have representation in their immigration cases and must proceed alone. 18 organizations from across the country can post children's cases to this platform that need pro bono representation. So there are opportunities nationwide. So you can visit this platform on our website or using the codes here on the slide. We hope you will stay connected with CELA. You can sign up for CELA's monthly newsletter. Check out our website to learn more about us, see upcoming trainings and working group meetings, request technical assistance, and view some of our written resources. Thank you so much for joining this 101 webinar on options for survivors of crimes, including trafficking. We hope it provides some background as you get started in this work. Thank you.